Hello, my name is Christopher Badger, barrister at Six Pump Court, and welcome to the 4th edition of our Environmental Law News Bulletin, brought to you in association with LexisNexis. In this bulletin, we look at recent environmental developments within Brexit, movement by the European Parliament to tackle emissions, and the new enforcement and sanctions policy from the Environment Agency. Michel Barnier has stated that the EU will insist on a non-regression clause in any future deal after Brexit in order to prevent the reduction of pre-Brexit standards. In a debate in the European Parliament on the 10th of April, he said that the 27 member states would be extremely vigilant in blocking any attempt by the British government to undercut current regulations to gain a competitive advantage. His view was that there could be no ambitious partnership without guarantees on fair competition, social standards, tax dumping, and environmental standards. The standards of the UK are inevitably going to diverge from those of the EU post-Brexit. At present, the British government's rhetoric is that it wishes to raise environmental standards, demonstrated by the 25-year Environment Plan. However, Michel Barnier's proposal of a non-regression clause written into the final agreement raises a number of practical issues. How will it be policed? Is it the EU's intention to leave open a role for the European Court of Justice to monitor the activities of the UK after Brexit, with a view to stamping out any competitive advantage that it perceives has been obtained through a reduction in standards? Who will hold the UK to account? Are we likely to see complaints from EU member states that the UK has breached its Brexit obligations, which could then result in sanctions being taken against the UK? Will citizens have a role in the complaints process over perceived reductions in environmental protection? Why is it assumed that the European model on environmental standards is superior in approach? Assuming that the UK is not going to engage in widespread environmental dumping of standards with a view to obtaining a competitive advantage over the EU, then will a non-regression clause actually hinder the development of UK environmental policy as a result of a misconception that divergence must somehow equate to an unfair advantage? The EU is concerned to see a level playing field following Brexit. The UK is unlikely to agree to tie its own hands in the future of the development of UK policy. At the same time, the House of Lords is debating amendments to the Brexit bill. The recently passed Amendment 11 prohibits the amendment, repeal or revocation of retained EU law relating to environmental standards and protection, except by either primary legislation or alternatively by secondary legislation that complies with strictly defined criteria, including an enhanced scrutiny procedure. The amendment still has to be accepted when the bill is returned to the Commons. Otherwise, it will be referred back to the Lords in a process affectionately referred to as ping-pong. We may find ourselves moving towards some form of policy of equivalence with EU environmental law, which makes the issue of equivalence and how that should be judged even more important. But while the Brexit debate continues in the Lords, the EU continues to advance environmental measures with a view to meeting Paris commitments. On the 17th of April, at a plenary session of the European Parliament, 2 draft laws with binding national emission targets were adopted. EU targets are to be turned into binding national targets for sectors that are not covered by the current EU emissions trading scheme, essentially agriculture, transport, building and waste, which together account for about 60% of the EU's greenhouse gas emissions. The cuts are intended to contribute to meeting the EU's overall collective pledge under the Paris Agreement on climate change to deliver a 40% cut in greenhouse gas emissions in all sectors from 1990 levels. The effect will be to commit the UK to a reduction in greenhouse gas emissions of 37% from its 2005 levels by 2030. Secondly, the European Parliament also adopted a separate law aiming to cut greenhouse gas emissions from land use and forestry and boost the level of emissions absorbed by forests as a way to tackle climate change. Currently, EU forests absorb the equivalent of nearly 10% of total greenhouse gas emissions each year. The proposed law would lay down rules under which EU countries have to ensure that deforestation is balanced by planting new trees, and sets measures to develop the sector in order to boost CO2 absorption by forests, croplands and grasslands. From 2030, Member States should endeavour to boost CO2 absorption so that they exceed their emissions. Both drafts will need the European Council's formal approval before entering into force. But it's precisely this type of development where the UK risks losing its voice following Brexit, but depending on the Brexit negotiations, may inevitably be required to follow. The Environment Agency has published its new enforcement and sanctions policy, combining and amending its previous published documents. The new single revised enforcement and sanctions policy has been widely welcomed. At the same time, the natural capital calculator has also gone online, which is to be used to guide enforcement undertaking offers following pollution events to water. The consultation response document provided a number of interesting developments, reflecting on the issues that were raised in the consultation, in particular in respect of the use of variable monetary penalties. In order to explain the Environment Agency's assessment of culpability at an early stage, it is now proposed to include the culpability assessment and a summary of the reasons for it in the Notice of Intent to impose a VMP, as well as a summary of the environmental harm caused or risked and the facts behind it. There will be no panel involved in the decision-making process for a VMP. The views of the investigating officer and the lawyer who reviewed the case will contribute to the decision on whether a VMP is an appropriate disposal, subject to the general oversight of the civil sanctions regime by directors. The wording of the draft policy has been revised. Previously, it had stated that very large organisations will be treated in a class of their own. This has now been amended to may to reflect the wording of the sentencing guideline. And the natural capital calculator is only one choice for assessing the appropriate sum to be proposed in an enforcement undertaking offer. And the Environment Agency would like to work with others to refine the model. Variable monetary penalties are yet another possible alternative resolution to criminal proceedings. It remains to be seen to what extent they will gain any traction in environmental enforcement. However, to the extent that they may represent a cost-effective and proportionate enforcement response, key to their development will be the level of engagement by the Environment Agency with affected parties, and whether or not that engagement includes the opportunity to make meaningful representations in order to determine an appropriate informed decision. Thank you for tuning in for this Environmental Law News Bulletin. For more information on any of these stories, please contact Six Pump Court or my colleagues at LexisNexis. We'll be back in May with a look at some of the month's key legal updates.